Good morning. I'm Dr. Harvey Schipper, and I'm with you from Winter Wonderland, Toronto today to engage in a discussion with three distinguished Canadians about a social change, legal challenge, medical challenge that has started to consume this country and has grown over a number of years. And that's what we call in Canada medical assistance in dying. The story of this goes back many, many years, but in the mid-1990s, there was a Supreme Court case called Rodriguez, in which, in a very fraught decision, the Supreme Court, by a 4-5 decision, decided it could not find grounds to authorize the legally assisted, medically assisted ending of life of a woman who suffered from a severe progressive neurological disease. A number of years later, the case was revisited in something called Carter. And the change in thinking at the time was a new legal argument that opened the discussion to the Supreme Court. And that argument was that by denying someone in a very similar circumstance with a severe neurodegenerative disease the opportunity to have life ended on their own terms was in fact an unconstitutional thing because it would force the patient to end their life earlier than it otherwise would. And that led to the landmark, socially changing Carter decision. That in turn forced the federal government to enact Bill C-14 just about 5 years ago. And that piece of legislation, in narrow terms, framed around the Supreme Court decision, made legal the active ending of life in very defined circumstances and added some very strict caveats that mental illness would not be a sole criterion, that there could not be advance directives, and that this was not available to what we call mature minors. Further, it mandated the formation of an expert panel to assess the evidence and mandated that after 5 years, the experience be reviewed before making any further changes. About a year ago in Quebec, a decision called Truchon was issued by a lower court, in which the C-14 phrase, death reasonably foreseeable, was found to be unconstitutional because it discriminated against people whose death was not reasonably foreseeable. And that decision in the court in Quebec is what's driven Bill C-7, which is now processing through Parliament in a means of resolving the issue. C-7 has a much broader range of application and has triggered intense discussion, controversy, debate, and a range of nuance that I don't think anyone had anticipated. To discuss this further and perhaps bring some light to it and offer some pragmatic approaches to how we deal with this almost intractable complex problem, we have a very distinguished panel who are joining with me today. The first is Leonie Herx, who's the professor of palliative care at Queen's University. And following that, we'll hear from both Andrew Coyne, the distinguished national journalist, and Harry Swain, a senior retired former public servant. Let me start with Leonie, who is professor of palliative care at Queen's University, has been deeply involved in this issue for many years and has become a voice in the argument. Leonie.
Thank you. And thank you to the Macdonald-Laurier Institute for hosting this important discussion on such a challenging issue before us today and for the opportunity to contribute to this panel. I've been thinking, writing, and speaking extensively on the issue of MAiD and its impacts on medicine since the Supreme Court ruling 6 years ago. For millennia, the practice of intentionally ending the lives of patients has been removed from Western medicine, and do no harm has been a core principle of medical ethics. Healing life and ending life could not and did not occupy the same space in medical practice. Until very recently, doctors who did cross this line have been judged very harshly by history, including those who participated in the German medical experiments during World War II, forced sterilization of Indigenous women, and Jack Kevorkian, who was convicted of murder. By bringing ending life back into the practice of medicine in Canada through MAiD, we have fundamentally changed the role of the physician. We have seen a growing acceptance and normalization of the role of medical practitioners who want to facilitate death for patients who are approaching the end of life. But what is coming next for medicine under this Bill C7 is truly internationally unprecedented. The amended Bill C7, now before the House of Commons, extends MAiD to those who are not dying, but who may have a disability, chronic disease, or even mental illness as a sole condition, whose capacities are said to be irreversibly declined. There is no requirement for a patient to have tried standard medical therapies, even in the case of potentially treatable conditions, before being able to choose death by MAiD. They only need to be informed of their options. Patient choice and informed consent are thereby set to dislodge the practice of evidence-based standards of medical care. Other permissive jurisdictions that allow MAiD for those who are not dying, and there are only 3 that allow physician-provided MAiD outside the end-of-life context, treat it as a last resort that has elevated a medically administered death as a first-line therapeutic treatment. In a family doctor's office, it might look something like this. A 25-year-old woman with a new diagnosis of rheumatism is afraid of the drug therapies and worried about what her future might hold with this new illness. Feeling depressed, she asks her family doctor for MAiD. Her family doctor must ensure she is aware of the options to treat her rheumatism and that she has carefully considered them. But under Bill C7 as written, the patient could refuse to try any of the evidence-based medical therapies that we know can improve her condition, her quality of life, and her mood. But instead, she may ask her doctor to facilitate her death through MAiD instead. Some physicians are now raising the alarm over this fundamental change and threat to the practice of medicine. That is, treatment based on patient choice rather than the standard of care. The medical associations and medical regulatory authorities that have come out in support of this bill seem to be oblivious to the seriousness of this shift. With time, many more doctors will be faced with a situation where they have to provide or facilitate MAiD when it is contrary to their medical expertise and professional judgment, because the law has made MAiD a first-line treatment for suffering. Doctors should be able to practice medicine according to their professional integrity and conscience, and currently that is at risk. Thank you.
Thank you, Leonie. So Leonie is a palliative care doc who reflects the perspective of physicians at the front line, at the coalface. The next person to join in the conversation is Andrew Coyne, a distinguished columnist well known to anybody who listens to the Macdonald-Laurier. And in recent months, he's written 2 columns related to this topic. One asking the question, are we going too far? And the other, the very provocative question, of course, of what's the role of the Senate in this whole conversation, and where do the legislators draw their inferences, and how do they make their decisions? Andrew, welcome and thank you.
Thank you, Harvey. In the space of a few short years, assisted suicide has gone from a crime to a right to a public service. Doctors who were for millennia forbidden to assist in a suicide are now required to do so, or to refer patients to those who will. As originally argued, assisted suicide was intended to apply only in the most extreme and unusual cases to mentally competent adults in the last stages of a terminal illness, suffering unbearable physical pain and yet incapable by reason of their condition of ending their torment themselves. That was what Harvey referred to, the Supreme Court decision was key to it, was to end the, quote, cruel choice facing people who might fear that they were going to be in that position, and therefore, as he said, this assisted suicide could be presented as a way of prolonging life, allowing them to live until they face that position and someone else could end their lives for them. But as we all know, that's not how things have developed. Eligibility for assisted suicide has expanded from physical pain to psychological, from terminal illness to non-terminal, from patients who are physically incapable of killing themselves to anyone. And most of that was done by the Supreme Court itself in its very ruling. Next to fall are the distinctions between the mentally competent and the mentally incompetent, and inevitably between adults and children. I say inevitably for a reason. Once you've accepted the basic premise of assisted suicide, that suicide is no longer to be viewed as a terrible tragedy, something we should wish, if possible, to prevent, but as a blessing in certain circumstances, a release from suffering we should hasten to assist, then you cannot impose conditions on its application. Its proponents asserted that we could dispense with all sorts of distinctions previously thought important between killing yourself and have someone else kill you, or between refraining from prolonging life and deliberately ending it, and yet we could impose at the same time all sorts of other new distinctions. So it is that a cause advanced in the name of a limitless individual freedom was defended with reference to how acutely limited that freedom would actually be. Assisted suicide was presented as if it were a conditional right, like the right to vote or the right to drive, something that could be limited to certain people and not to others, mentally competent adults, etc. But in fact, it quickly morphed into an unconditional human right, like the right not to be tortured. If that's the case, it can't be limited to the dying, to the sane, to adults. It must, by its own premises, be universal. Some of us said this at the time and were accused of slippery slope thinking. Well, as it turns out, the slope is in fact very slippery. We're left with a monstrous bait and switch. Had the public known 6 years ago that this was where we were headed, they would never have accepted it. And not only the public, the whole premise of the Supreme Court's Carter ruling was that the slope would not be slippery, indeed could not, that the kinds of rapid expansion we've seen in Belgium and the Netherlands, including to children and the mentally ill, could not happen here on account of our very different medico-legal cultures and all. Well, the Supreme Court, as I mentioned, started the ball rolling itself. Then we had this lower court ruling, the Truchon case. The ruling was not required by Carter. The Supreme Court may have declined to insist on, quote, reasonably foreseeable death as a condition, but it did not say that governments could not. It said a minimum condition for access to assisted suicide, intolerable suffering due to a grievous and irremediable medical condition. It did not say this was the maximum condition that could be set. And then, of course, the federal legislation coming out of Truchon goes even further than the court required. And the Senate would take it further still. And others will go further than the Senate. We must begin to put some boundaries around this debate. We're not talking about the right to kill ourselves, but to have others kill us. That makes it more than a matter of pure personal autonomy. It implicates not only the person who assists in the suicide, but all of society. As such, we are entitled to define some terms, to make it as narrow and as limited an exception from the millennia-old total ban as we possibly can. I would like to see us with the federal government withdraw this legislation. I would have preferred that they had appealed the Truchon case. I don't see why they didn't. And I don't think it's beyond capacity or beyond reason that they could ask the Supreme Court to revisit the matter. The justification for Carter in overturning Rodriguez was that the facts had changed from that earlier ruling. Well, the facts have changed again. The slippery slope is not a fallacy, not something that can't happen here. It is real. It has happened here, and it's going to continue to do so.
Thanks, Andrew. So we're in a very interesting position now where in Bill C-14, the government mandated, among other things, a detailed review of the experience of over 5 years before moving on. A court case that Andrew has mentioned, Truchon, comes forward, and the government moves in advance of that to change the legislation. And that raises the whole issue of how this fits into a rational, appropriate format for designing legislation to represent the needs of the country. And I can think of nobody better with broader experience in that kind of work in government than Dr. Harry Swain, who during his career in the civil service served as deputy minister in 2 major departments and has had a long history of overview, advice, and consultation on the manner of government. Harry, welcome. You're muted, Harry.
There we are. Thanks.
Okay.
I want to pick up a couple of points that have been kind of mentioned en passant here. One is the parliamentary mechanics of all of this. When the original bill was passed in 2016, there was a promise embodied in the legislation that a good deal of research would be done on what happened with the original relatively limited circumstances that the law allowed. This would have been before the Parliament in the fall of this year, let's say. The problem, of course, is that it can't be because they haven't done the work. We do not have the research on what has been our experience of the last 5 years or what has been the experience of the individuals involved. We have some information about the people who have availed themselves of medical assistance in dying, but it's mostly process stuff where the right boxes ticked off to, the consent found in the correct way and so on and so forth. We don't know very much about their circumstances or why they chose what they chose or what they were thinking about. We also know absolutely nothing about the number of people who applied for MAiD and were turned down. Nothing at all. There's a whole, I mean, you could make careers, of course, out of finding the details of all this, but even at the broad strokes level, the government has not lived up to the promise that it made in 2016. One of the other promises that was made in that bill was that MAiD would not be allowed until and unless a high quality of palliative care had been first offered. Now that's a problem. Palliative care does not exist equally across this country. It's pretty patchy. I spent 5 years in the Department of Indian Affairs, and I tell you that now as then, that's not routinely available in Indian country. At the very least, it seems to me that before one gets into a discussion about medical assistance in dying, that every serious step on palliative care would have been taken, that the conditions that lead people to request medical assistance in dying, or lead them to suicide, be alleviated to a quite remarkable degree, and they have not been. All right, now then let's go beyond that a little step. The parliamentary mechanics of this are interesting. There is to be the 5-year review. The bill was to be reopened in the fall of 2021, and we're all got interrupted by Truchon, a rather daring and far-reaching decision by a lower court judge, applicable only in Quebec, which has been used as the goad and flail, to use a term known to Andrew, for getting a new bill up and running. So we get the new bill, C7, broadens things rather considerably and opens the question of whether this is in extremis or somehow a fundamental right. And off it passes through the House and goes off to the Senate. The Senate becomes seized of the issue and, exercising their sober second thought, opens the door even further. This is quite a slope. So now the bill that the Senate has sent back to the House has really opens the door quite a long way. And the House is going to figure out what to do about it if the Tories allow a debate in a reasonable amount of time. We'll know the result of all of this maybe even in a week or so. Even then, the bill would have to go back to the Senate reconsider. The Senate might or might not agree with Andrew that there are limits to what unelected folks can do, but hey, that's judges too. And away we go. There will be, I'm sure, some thought in the cabinet and in the caucus of the governing party that, gee whiz, wouldn't it be nice if we had an election or some other excuse to let this die on the order paper before we have to leap off the cliff. Thank you.
So what was originally posited as a relatively straightforward kind of human rights issue, if you will, going back to Carter, has become a much more complicated, nuanced thing who, in my experience too, extends much more broadly into the community. I've spent a fair bit of time talking with people about this. I'm a physician. I also teach in the law school, and I've been asked to give talks about it. And what fascinates me is how people who even claim to be followers of the issue and are well-educated, thoughtful people are quite confused about the issue. You know, I remember sitting down with one group in a repeated kind of experience where they thought that the Carter decision really was about allowing people to decline or withdraw from care, as distinct to the active ending of life. Andrew, you made comment the other day about complex issues where people come to opinions but don't understand the nuance, and that this might be one of them. I wonder if you would like to venture a bit there.
Yeah, well, it's a particularly dangerous issue, obviously, partly because of the stakes that are involved, but because it's one that people think they know about. They don't even know that they don't know, which is, you know, oftentimes on issues people will defer to experts or to, you know, consensus opinion. But on some of these issues, people will have read about it in the press some years ago and think that that's where the issue still stays. And so, as you say, people either think it's about you know, refusing heroic measures, or they think it's about what it was about in the original case, people who are nearing death anyway, in terrible pain and agony, and in this quote unquote cruel choice where they can't simply kill themselves. They're stuck with a situation where the only way they can end their life is if somebody helps them. Now, you know, opinion may have shifted in terms of people's willingness to accept that, but that's a long way from where we've arrived already and where we're headed for. So that very extreme, unusual type of circumstance that was the basis for getting into this was pretty quickly pushed to one side. And I say the strangest part about it is it was pushed aside by the Supreme Court itself, even as it was ruling, and there's language to this effect in the Carter ruling, that this should only apply in circumstances similar to the case in front of it, which was about somebody in, you know, irreversible decline, et cetera. So the Supreme Court itself started the ball rolling down the hill, if I can mix my metaphors, and ever since, each time somebody comes near it, some body or group comes near it, they push it still further.
Positions taken, and it was alluded to in the press release that came out Friday from the ministers, saying, we want to advance this as quickly as we can to relieve the suffering of those in these categories for which we want to make this available. People have said to me, and you're much closer to it than I am, that there's a body of suffering arising on the other side of the issue. In other words, people who suddenly are confronted with the possibility of MAiD, or physicians presenting that possibility, causing difficulties, if you will, on the other side, you know, suffering the anxiety or what have you. Can you speak to that a bit?
Are you talking to me, Harvey? Sorry, you cut out a little bit earlier. Yeah. So that's become a real issue through this debate around what's being pushed as a duty for doctors to inform all eligible patients about MAiD as an option. And the problem with that is, in part, the power imbalance that, whether we like it or not, does exist within a patient-doctor relationship. Doctors are trained, like I have 17 years of university training. I've worked really hard to become an expert in my field. And when patients ask us for advice, we're making a informed medical recommendation that we think is in their best interest. And most patients want our advice because of our training and skill and expertise. And so a patient who hears from a doctor, well, you should consider MAiD, just by that nature of that trust and the power imbalance in the doctor-patient relationship, that could be all the nudge that person needs to think, well, geez, I should really consider it. And I've actually had patients tell me that, their trusted surgeon recommended it, so they really thought their symptoms were going to be very severe and they really better consider it. The other issue is that patients who don't have access to the care that they need to live through ableist views, discriminatory practices within our healthcare system, then you have a doctor suggesting MAiD to them. They already are made to feel that their lives are less worth living because they don't have the same access and rights to care that average Canadians expect to have. And then you say, well, you should consider MAiD as an option. It actually can be a form of pressure or coercion. And we've heard lots of firsthand testimonies through the parliamentary hearings, as well as in media reports of vulnerable, particularly disabled Canadians who have been told unsolicitedly that they should consider MAiD. And that truly is a very big concern for many doctors and for patients, that this is a form of coercion and may force people to consider MAiD when they certainly would not have before.
So in that respect, Leonie, do you think it changes the doctor-physician relationship more broadly or just in the narrow context?
Well, I think it also comes back to that concept of the standard of care that I spoke about, that our duty as doctors is to present to a patient based on the best medical evidence, knowing the person and their values and wishes in their unique context, what would be the best options for their care. I can't even fathom telling someone that they'd be better off dead, which is, presenting MAiD as an option certainly implies to people, especially who've been discriminated against, that their lives somehow are less worthwhile than other people's.
So quite related to that, a question has just popped in again for you, Leonie, and it says, if I may, and it's I think it's from Chris as I'm reading it. MAiD is on the palliative care spectrum, but also that it is distinct from palliative care. With respect to the relationship, can you talk about how palliative care and MAiD are connected?
Yes, thank you. That's actually a very important question, and one that palliative care clinicians and our national palliative care societies have really tried to help people understand. In fact, intentionally ending someone's life is contrary to the core principles and philosophy of palliative care, and that is accepted internationally. Our discipline developed to bring exquisite expertise, impeccable symptom management and assessment across all the domains of suffering that people experience when facing the possibility of their own death, and to support someone having the very best quality of life until they die, definitely not to do anything to hasten death. And that is part of the definition of our specialty. And so there's been this misunderstanding, this interpretation that, well, palliative care gives, big doses of opioids, morphine at the end of life, that shuffles people along more quickly to the death. And, what's wrong with that? That actually is illegal and should not be happening. We carefully use medications to titrate symptoms. I would say that that's, not good medical practice, and that's a myth about what palliative care does. So, in fact, the intentionally ending of someone's life through MAiD is a very separate and distinct practice that can happen in parallel to palliative care. So someone does not have to forgo palliative care if they end up choosing MAiD, but that is very clearly not what we do. And it has caused a lot of confusion about palliative care and MAiD because of the euphemistic terminology. So the term medical assistance in dying leads people to think, well, we're aiding people in dying more comfortably. That's what palliative care does. That's what I do every day, and I help patients much early in their disease trajectory as well, certainly. But we certainly make sure that we provide excellent symptom management and accompany people through to their natural deaths. That is not what MAiD is. MAiD is the intentional ending of someone's life through a lethal injection in Canada most often, or assisted suicide. And they must be kept separate and distinct so that patients understand the difference between the two.
So you're a patient or family member of a patient who has widespread, say, metastatic prostate cancer and is having a lot of pain and has been through the range of treatments that are out there, and you've tried to relieve the pain as best you can, and you're having difficulty, and up comes this notion of what you call palliative sedation. And how is that distinct from MAiD? It's a question I get asked all the time.
Yes, and that's been confused even in the most recent Senate hearings that they had on Bill C-7. In fact, senators themselves continue to speak incorrectly to this issue. So palliative sedation is a tool that specialist palliative care physicians have developed to ensure that people that are at the very last days of life, so their natural death is within days, can have their refractory symptoms controlled if there are no other measures to control those symptoms. It's very rarely used because we actually have very good tools to control pain in almost every circumstance. There are very few people that are in their last days that have these uncontrolled symptoms. And that's why it is recommended that if a patient has difficult to control symptoms, you consult a palliative specialist who has the additional training and expertise to make sure all the stones have been turned to optimize this patient's symptoms. In that very strict parameters around death is coming soon, symptoms are refractory, we can use palliative sedation to ensure that a patient is not suffering from those uncontrolled symptoms. It puts a person into a level of sleep that's necessary. So it doesn't have to be that they're sleeping, but it sedates them to a level necessary that they're not experiencing distress from their symptoms. When used in those very specific parameters according to guidelines and titrated carefully, it does not shorten a person's life. It's been shown in randomized control trials. It does not hasten death. The person dies from their natural underlying illness, but are made to ensure that they're comfortable during the dying process.
We'll come back to the clinical questions in a moment, but a listener has raised a question that also resonates with me, and I'm going to direct this to all of you, but I'll start it with Harry Swain. Here we are making a policy decision using legal thinking. In other words, that's how we got from Rodriguez to Carter to Truchon, and we're changing legislation based on legal reasoning. We are not applying, if you will, clinical bedside reasoning. In other words, the research as to what the outcomes of our interventions have been. In other words, we're using a different frame of thinking, and one might argue that one is inappropriate to the issue. So the question from a YouTube user says, do any of the speakers have thoughts on why we have not seen any research or any transparency from the government on this issue? Harry?
Well, I was just complaining about that. And I don't know why there has not been research on this issue. I would have thought it was a natural for the Social Sciences and Humanities Research Council. Maybe they didn't get any good quality research proposals. I don't know. But going well beyond that kind of responsive funding of research from highly qualified people in universities, it seems to me that the government could have, should have, established its own kind of inquiry. And I don't mean a big judicial inquiry with all of the process that surrounds that, but a study, or perhaps several parallel studies of particular aspects of all of this, so that we would get some, not a reporting of emotion, but some facts on who was involved, what happened to them, why, what is the nature of the unfulfilled demand for this service, and so on. I don't know why the government didn't do it. The notion of putting an opener into a bill where, you've got some remaining questions is not at all uncommon. I remember doing that with the Bankruptcy Act back in the 1990s, where Parliament had said there were some questions that still remained, and we will be reopening this bill in 5 years' time. And we had quite a serious process to to deal with that. In this particular case, it involved the Department of Industry convening all of the interests, plus a few distinguished outsiders who didn't have a particular view on this question, but knew the history and the law very well. And off we went. Essentially, what we told this broad group with all kinds of strongly held opinions was, anything that you guys agree on, I guarantee it'll be in the bill. But there will be a bill, and if you don't agree, I'll write it. And that scared the willies out of them, and we got a good result. There are lots of processes that you could use here to inform the quality of the debate in the public, in Parliament, in the Commons and the Senate, that we've just completely missed. And one can only put that down to the government not finding it was sufficiently important to put on their work plan and to live up to the legislation that they introduced.
Andrew?
I'm not sure. I think I'd frame it a little differently. I'm not sure I see a conflict between legal reasoning and fact-based inference. Good legal reasoning is supposed to be informed by facts, and particularly in this case. Let's go back to Carter. The reason why the Supreme Court felt entitled to overturn the Rodriguez decision from 2 decades before, which had upheld the law banning assistance in a suicide, was that the facts on the ground had changed. So what had changed? Well, at the time of Rodriguez, there was virtually no place on earth that had a regime. I think maybe just the Netherlands, but at that point, there was very little experience to draw on. And so the court decided to err on the side of caution. We've got to keep an absolute ban because of the risks of this metastasizing and spreading and being abused and all those worries and concerns. And so by the time Carter came around in 2015, the court said, well, we've got some experience now in other countries, and we don't think those concerns are quite as overwhelming as they might have been at the time of Rodriguez. Now, the odd thing was, if you looked at a lot of the evidence from the Netherlands, from Switzerland, from Belgium, it was quite disquieting. And the court kind of waved that away and said, well, that evidence isn't really worrisome to us. It's anecdotal. Those are different countries with different cultures. So they kind of selectively parsed out the facts. But nevertheless, they were arguing, so they said, from facts to inform their legal reasoning. And so therefore, we're entitled, they said, to overturn precedent. Usually courts are supposed to defer, even the Supreme Court is supposed to defer to precedent unless the facts have changed. Well, as I say, since the time of Carter, we've got a lot more experience in Canada and elsewhere. And it seems to me all of the evidence shows that, in fact, that careful, limited, tightly controlled exceptions that the court was talking about, even though it itself loosened them even further than they were asked to, they're not tenable. That once we get down onto this kind of reasoning, where you're not talking about, people keep trying to call this assistance in dying, but once you've removed reasonably foreseeable death, it's not even about that. It's about people who have whatever condition in their life that makes them feel at the moment that their life is not worth living, that we're going to allow people to assist them to end their lives then. So it's not about assistance in dying, it's about normalizing suicide. So that ought to be very disquieting to any of the proponents of this from 5, 10, 15, 20 years ago, that this has gone to a very different place than they perhaps intended.
Leonie?
Just a brief comment to add to what Andrew and Harry and you have already said on this particular topic is that I think that the Senate did hear from a broad variety of voices on this that expressed significant concern, and they really didn't listen to those voices. So I think that's something just of note, that what they put forward to the House of Commons in terms of their amendments was not reflective of the deep concern that was expressed from the witnesses they heard from.
It's particularly extraordinary that something is advanced in the name of the disabled that dozens of disabled groups themselves do not want and have protested vehemently against. Because essentially, when you hear a lot of people talking about this, there'll be able-bodied people who would say, oh my goodness, if I was a quadriplegic, I don't think I'd want to continue living. Well, what is the message we're sending to people who are quadriplegic today? why would they not take it as basically the rest of us telling them your lives are not worth living?
It's
Or
fascinating.
we're not going to pay the cost of keeping you alive.
Yeah.
Well, and that's kind of the Archie Rowland story from Quebec, right? Among others. Archie Rowland was another gentleman with a degenerative neurological disease, sharp mind in terribly constrained body, who was carrying on, given the circumstances, quite well in an institution in Quebec with both the staff and technological supports required, and an administrative decision was made to move him elsewhere. And the elsewhere provided neither of those supports, and when after a period of time he couldn't regain them, he requested and received MAiD, which, for many people was very disquieting. The story actually wasn't that widely heard beyond Quebec, interestingly enough. My patients ask me about this fairly frequently. They say, does it compromise your role as a physician? Should doctors be the one, and nurses or pharmacists or whatever, should they be the persons doing this? And if they are going to be the persons doing this, what form of training, what form of oversight, who provides the oversight for this very unique role that someone, and has more than one person, has actually called being a death doula? So my question for you is, does it compromise the role of a physician? I know, Leonie, we edged onto that before. And how would these people be identified? What would the process of oversight be? And what do we know now about how that happens?
Oh my gosh, that's a huge topic. Well, I think to start with your first question about does that compromise the role of a physician, I think it does. I think if a doctor is suggesting MAiD as an option, patients might seriously consider it, as I said earlier, when they wouldn't have before, especially if they don't even have access to services that they need to support them in living, to have their symptoms addressed, to have their basic needs met in some cases, right? We don't have a right in Canada to access home care, disability supports, palliative care, housing. All of those things should be guaranteed under the Canada Health Act as rights, just as MAiD has been made. And we've been arguing about that from a palliative care perspective. And of course, the disability community has been vocal on this, that they need supports for living before someone offers them death. So I think it does compromise a physician. And many physicians are distressed. Even physicians who are pro-MAiD are distressed if they are faced with a situation where a person is requesting MAiD, which we're seeing an increasing frequency and amplified by the COVID-19 pandemic, because they don't have access to care. They're forced to live in long-term care situations that are frankly appalling. We've seen a recent case like that. All those cases you've referred to, Archie Rowland, Jean Truchon himself said that he wasn't asking for MAiD because of his condition, but because he didn't want to live. They didn't have the supports to live outside of an institutional setting. I know I'm digressing from exactly the question, but these are like huge issues that the solution is not to be offering death to people, it's to be supporting them in living. At a bare minimum, MAiD should be an absolute last resort. This C7 legislation is so frightening because, as I said in my comments, it could become a first-line treatment when even treatable, easily treatable conditions, there's no requirement to have tried anything. And you could just ask your doctor for MAiD, or your doctor may become obliged if the colleges of physicians and surgeons have their way about bringing up MAiD as an option, making doctors forced to do that. Your doctor could say, well, you can get MAiD, and then you get it. Like, I know there's more parts to your question, but I'm wondering if I see Andrew nodding his head. I think he might want to jump into huge issue.
Well, just very briefly, I think it's worth asking why we want doctors to do it. Mm-hmm. It's not something that requires the full range of expertise that a doctor possesses. It has very different issues. You're not really concerned whether the patient survives. I think the reason why we want the doctors to do it is so we can pretend we're not doing what we're in fact doing. We can treat it as if it's just another medical treatment and not what in fact is ending someone's life. So I think it's a kind of wishful thinking or an attempt, a sort of a euphemism almost in the way that we approach it, to soften it, to make it seem like it's not what it is.
Harry, any thoughts?
No, I agree with the last two speakers.
So let's try to be a little bit helpful here. How best to navigate this? It's obviously not going to end with Bill C7, whatever happens to Bill C7. We've opened a Pandora's box that's going to go on for who knows how long. My daughter calls it an immortal project. So from each of our perspectives, Harry, Andrew, Leonie, what advice do we give, if you will, our leaders, so that over time we come to have this find, if you will, pardon the euphemism, the right place in society? Because I think we've come to the point where we're saying, hey, there is a place for this thing we've come to call MAiD. We haven't figured out what it is. Yes, there's some people who say no, never. There are other people who say yes on demand. But how do we find, that ground where, if nobody's entirely comfortable, at least that people can live with it and have some confidence that we've done something appropriate? How do you get there? And from each of your perspectives, I wonder if you could muse on that. Harry, do you want to go first?
The first thing I would do would be to let the current bill die on the order paper and start again. The fact of the Truchon decision is not relevant in process terms. It would continue to apply, I guess, in Quebec, but nowhere else. Second, I would. We now have enough information, I think, from the consultations and from principled statements from people that unless you first provide those necessities for living that Leonie was talking about, that you really shouldn't be talking about this at all, except in the most extreme and exiguous circumstances. So that's what I do.
Andrew?
I agree with you that you're not going to get an ultimate response that's going to please everybody. That's the nature of these things. I think you can get to some place that represents a kind of the center of gravity of public opinion. People, the sum total of people's moral intuitions on this, that will be fuzzy and not perfect and not airtight philosophical grounds, but will be better than where we seem to be headed. I don't think, I think Harry said the other day when we were talking about this, you can't necessarily put the toothpaste back in the tube, but you can put some of the toothpaste back in. And the more that you put back in, the more lives you're going to save. So I do think, I don't think we're condemned to just simply sliding down the slope as far as we can. But I do think people who are concerned about this, to whatever extent they're concerned, and some people are more adamantly opposed to it than others, but to the extent that one has any concerns, to try to put some boundaries back around this. And that requires, I think, seizing or attempting to seize the moral high ground in this, and not simply ceding the idea that this is only about personal autonomy. And when we're so we're so conditioned in our society, and rightly so a lot of the time, to want to uphold individual dignity, individual choice, etc. But when you are talking about something that is not purely a self-regarding act, when you're talking about the involvement of other people, including the medical system in this, then at that point, I think you enter into a different territory where you are permitted as a society to place some limits on it, some conditions on it. And those conditions are probably not going to be the absolute ban that we had prior to Carter, but there's no reason why they can't be awfully close to that, where you can make exceptions for the kinds of extraordinary and extreme and unbelievably cruel dilemmas that people face in certain very limited circumstances, without going all the way down the road of basically saying, as people are saying, that you should have assisted suicide available for people who have anorexia nervosa or who have obsessive compulsive disorder, or as in Belgium and the Netherlands, where it's been, I'm not sure, I forget whether it's been actually implemented, but where it said that people who were serving life sentences in jail should have access to it. At that point, as I've said before, you're not talking about assistance in dying, you're talking about normalizing suicide. And we have, as a society, even with regard to mentally competent adults, we have a responsibility and obligation not to go that direct, let alone with people with mental illness or with children.
Leonie?
Yeah, I agree with what Harry and Andrew has said. I think this bill can't be fixed in its current form. It is indeed an assisted suicide bill for anyone who is suffering of any kind, including being used in the prison system for people that don't have rights to access basic care, but have, it could be seen as a tool, and already is being used as a tool to get out of where they have no ability to have their care needs met or get parole even at the end of life. This, at a bare minimum, as I mentioned earlier, like, we have to have this as a last resort for people under very strict circumstances who are near death, as you've described, Andrew, when everything else has been exhausted, not as a first line medical treatment. We have to have substantial conscious protection for all healthcare professionals, because this is a moral issue. It's also an issue around our role as professionals. And some regulatory authorities have made it about, this is your personal religious views. It's not. This is about my role as a palliative physician. It could be about your role as a rheumatologist. You know that you have treatments available to help a person, and yet you might be forced to facilitate ending their lives when other options still exist. So we have to have robust conscience protections that are legislated, because otherwise professional bodies can change their policies at any time. That is an imperative that must happen in order to move any kind of MAiD regime forward in our country. We have to have that. And we have to guarantee access to care. And I'll say it again, we have to put home care, disability supports, palliative care, we have to make them part of the Canada Health Act, so that provinces have a duty to fund them and show how they're improving access, because currently the resources are actually being diminished, not increased, in palliative care specifically through MAiD, because MAiD is actually being provided by some people who were being paid to provide palliative care, for example. So effectively diminishing already poor access to palliative care.
As a footnote to all of this, I would simply say that if you pass an expansive act and you put it all into the law, then going back, taking away rights that have thus been granted, getting to that reasonable place that Leonie and Andrew are describing, it becomes that much harder.
Yep.
Maybe impossible.
Yeah.
There are quite a number of questions that have come in that wanted to ask about particular aspects of the bill or the amendments that have come forward from the Senate. And thus far, we haven't engaged any of the specifics, because we were sort of trying to focus on the broader issues of the bill, how it was brought forward, what its intention was, and so on. But and I'm going to pick on one because it's a kind of fascinating one, and it has to do with the notion of advance consent. And what advance consent means is that you decide today that in the face of a certain circumstance at some tomorrow, we will do something. In this case, provide MAiD. And I've had this one asked of me quite frequently in the context of Alzheimer's-like diseases, where people, are very afraid. I got a phone call a few weeks ago from a gentleman, from the family of a gentleman with his support, whose brother and father had died of an Alzheimer's-like thing. And he was fairly robust and in his mid-70s and had now developed early stage Alzheimer's. And knowing the apparent genetics, if you will, was very concerned and thought, I wonder if in that kind of circumstance, an advance directive made sense. People want to reflect on that, and I'm going to hold Leonie till the last. Andrew.
I suppose it raises this fascinating philosophical question of whether you can speak for your future self. You apprehend some future circumstance you would think would be intolerable to you. And so you make the decision now. But in the future, in that situation, knowing and having that experience, maybe you wouldn't find it intolerable. Maybe you would regret that choice. Maybe you would wish to countermand that previous statement. Maybe that's far-fetched, but if to the extent that that applies at all, then I think we should be very concerned. I mean, most of the time, we are very concerned that not one life should be taken in error or wrongly. When it comes to the legal system, for example, we go to extraordinary lengths, where we did when we had the death penalty. We went to extraordinary lengths to make sure that nobody was ever wrongfully convicted, wrongfully put to death. It seems to me we're under no less obligation when it comes to the medical system to make sure that we're not opening that door for people to make choices that they might have come to regret, but never get the chance even to regret it. I mean, one of the extraordinary things in Bill C7 is that they removed the earlier requirement for even a 10-day waiting period. 10 days. The data that we have, and it's fragmentary so far, but the data that we have, I believe the number was 265 people to date who had earlier signaled that they wished to to be assisted in their own deaths, changed their mind in time to prevent it from being carried out. 265 people who are alive who would otherwise be dead. I think that should weigh heavily upon our conscience and on our choices in this matter.
Harry?
I really can't add anything to that at all. That's a fine argument.
And how does one frame that within the context of policy making? How does one bring that to bear?
In a question of that nature, which is fundamentally value laden, which goes to deep moral feelings that we all have as individuals, there is not a lot that the professional policy advisory apparatus can do for you. And you can write it down. You can say, some people feel like this, some people feel like that, and so on. But the decisions on this come right from the heart, and parliamentarians are every bit as good at doing that as all the economists and lawyers and whatnot that you can imagine. So I'm not sure that there's a lot that, let's say, the professional apparatus can do here, except perhaps put some of these arguments in order or in a comprehensible form, let's say. Write a good cabinet memorandum. That's about it.
Leonie?
Just to build onto what Andrew said, that there's just no way when someone can't speak for themselves to know that's, how they feel about their life and if they want to go ahead and have their life ended at that point. They can't tell you. There's, already in this legislation, some concerning language about how a person's physical responses to when they decide to administer MAiD would be interpreted. Where this went in the Netherlands is that they have now a coffee euthanasia clause. That's actually the term that came out just in the fall, where if a person with dementia, someone else is deciding, whether it's a doctor or a family member or a committee, that now is the time to enact their advance directive and their life is no longer worth living, which is a whole separate issue we don't have time to discuss today. Someone else is deciding a value judgment that their life is no longer worth living. But the coffee euthanasia is they are worried that that person might not understand what they're doing to them because they have dementia. So they're going to put a sedative in their food or their coffee prior to administering euthanasia so that they won't fight back. Like, that is the type of thing that would come to Canada if we go ahead with this, because there's just, how do you respond to that? Like, it's just unfathomable, actually.
Well, I notice we're at 59 minutes and 27 seconds, and we have 60 minutes. So allow me just to take the last 30 seconds to thank my colleagues, Andrew and Harry and Leonie, for what I hope has been a significant contribution to the Canadian dialogue about this issue. And I think our mutually expressed hope that this very, very difficult, fraught topic be considered without haste, but with great contemplation, because in many ways, it's as profound a societal change as we've ever contemplated. So in that light, again, let me thank you. Let me thank the Macdonald-Laurier Institute for inviting this dialogue. And let's all continue to observe and hope that we march forward in an enlightened way. Thank you.
Very good.
Yep.
Thank you.
Thanks, everyone.